Please be seated. We have one case on the docket today, Leda Development versus the State of Texas. Counsel, make your appearance.
Yes, Your Honor. John Zerker, on behalf of the State of Texas, the appellate.
All right. We have not seen appellant's counsel, and it's now 2:05, and we haven't got any phone calls from the clerk's office. Hasn't told us that we're missing someone. So you have an option of giving an argument if you would like to, but you can also rest on your brief, whatever you would prefer to do.
I think that since I'm here, Your Honor,
Go ahead.
I can at least
Sure.
go through some basics. And
Yes.
I think just due to the nature of the briefing, that there may have been a bit of factual information about the case that would be helpful for the court to have.
Okay.
If nothing else, it'll give you one additional argument in case you want certification.
Absolutely. So certainly I appreciate that. All right, I'd say if you all
Whenever
are
you're ready. Yep.
Okay. All right. Well, may it please the court then. The state asks that this court affirm the judgment of the trial court and hold that no abuse of discretion has occurred as to any issue raised by Leda in this case. The key points that can be taken from the briefing of the parties, and especially the state's position, is that one, Leda failed to offer at trial most of the evidence that they complain of now on appeal. Two, Leda failed to preserve error both prior to trial and during trial. And third, Leda fails on all counts to demonstrate any abuse of discretion, which is the standard for which all of their claims are assessed in this case.
Was there any sort of pretrial conference that wasn't recorded that might have some of this missing information?
No, Your Honor. And in terms of the pretrial conference, I think one of the big issues that was kind of maybe not alluded to in the briefs as clearly as it could have been is that there's a general allegation in this case as to the exclusion of exhibits. So at the pretrial conference, Leda requested that 64 exhibits be pre-admitted. Now, the state did offer some objections during that pretrial conference to the exhibits, but the court pre-admitted one exhibit and pre-excluded one exhibit. The exhibit that was excluded was simply the full 180-page appraisal, full copy, which the state had objected to just under a hearsay objection without a response from counsel. So the court did exclude that. As to the remaining 62 exhibits, 58 out of the 62 remaining exhibits were never offered or attempted to be brought in through any witness during the trial, and so they are not properly before this court on appeal. During the trial itself, just to go through that information and just to provide a little background, while there has been some discussion in the briefings about the admission of evidence, I do want to clarify one part, and that I believe it's critical to know that the landowner's appraiser, Mr. Wayne Bear, was allowed to testify. During the trial, he testified to a value of $8.4 million based on his multifaceted opinion of multiple economic units, a proposed highest and best use of a multifamily commercial family complex, as well as a novel theory of damages. The state's appraiser then also testified to $32,000 based on a straightforward low-density industrial use for the land and no damages to the remainder. So obviously, those are pretty far apart, but it's the state's position in this case that the jury heard two numbers from experts' testimony who was not restricted. Both appraisers in the case were properly designated. Leda makes no complaints about their designation of their valuation witness on appeal. And so while there's some discussion about evidence and what was admitted or not admitted, one was almost nothing cited by Leda in their brief in terms of what the record, which again goes to the point of what actually got in at the trial level, is that they simply didn't offer any evidence. Going then to the complaint of Jerry Gaynor. Jerry Gaynor was never designated, who is a civil engineer by trade, and obviously that could potentially qualify him in some cases to be qualified as an expert. However, the key point in this case is that he was never designated as an expert witness, and Leda had assured the state and the judge at multiple hearings that he was only intended to be a fact witness. throughout the case. And for clarification, while Gaynor was never properly designated, the state during discovery did receive a report from Gaynor, or from Lita, that was entitled Expert Opinion of Jerry Gaynor. And so that was the reason the state chose to pursue a motion to exclude him in that capacity, just for clarity and so that we wouldn't come to the trial and see that he was now being offered and saying that the state was not prejudiced by the fact that it had priorly received his report. So we just sought to clarify that issue before trial. Notably, the state sought Gaynor's exclusion based on project influence, a failure to use reliable predicate, and improper speculation as to theoretical development as well as some hydrological issues. In terms of that, Lita chose not to file a response to the state's motion despite having more than 30 days to do so. And although he appeared at oral argument, he simply said to the judge that that Mr. Gaynor was not designated as an expert, was not intended to be designated as an expert, and would only offer factual opinions. So to the degree that Lita now, for the first time on appeal, claims that Gaynor qualified under some interested witness exception to designation, the state notes that the brief cites no authority for the fact that any witness who's going to offer testimony based on their skill, expertise, or profession has to be designated as an expert for the purposes of the case. Moving forward, the state, or Lita makes the general next complaint that the state's appraiser provided objectionable testimony as it relates to the highest and best use opinion that was offered during trial. However, again, during the case in chief, Lita objected only a single time to Mr. Domini's testimony. That objection was related only to the fact that Mr. Domini was not the administrative appraiser. Now, obviously, in eminent domain cases, there are two stages, the administrative stage and the trial stage. Lita's objection was simply that our witness had changed, and the state had offered to the court at that time that this is a de novo trial, and for the purposes he was properly designated, and at no point prior to the trial was any objection made to either his designation or, for that matter, to anything that he offered during the trial itself. Regarding the property owner, Mrs. Wynn, the state never sought to exclude Ms. Wynn. Throughout the conversations and discovery and what happened kind of at the pretrial conference, as well as the motion hearings on the state's various motions, again, Lita assured the state and the court that Mrs. Wynn was not going to be a valuation expert under the property owner rule, which obviously would have required some amount of designation, or at least certainly a basis on which the parties could evaluate her opinion, if any was intended to be offered. None was produced in discovery about a value that she might offer or a basis of that opinion, if any. So to the degree to clarify her role, she was only a fact witness. During her testimony, the state certainly objected at various points based on standard objections of leading and hearsay and different information. But as to those, there's nothing cited in Lita's brief as it references the testimony that she did offer, and so there's no way for either this court or certainly the state to evaluate in terms of an abuse of discretion standard as to what the judge did or not consider as to when those objections were made. And to the point, as I raised previously, generally in eminent domain cases, the testimony and expertise that comes down to it is that of the party's valuation witnesses. They are by far the most important witnesses in the case, and again, both parties' valuation witnesses, which is the purpose of eminent domain proceedings, were allowed to testify and testified to the entirety of their opinions without restriction. Then, seemingly in an attempt to overcome what we've noted at various points in terms of the briefing, that no error was properly preserved, Lita attempts a novel argument to make a common law claim of fundamental error. However, the Texas Supreme Court has made it clear on various occasions, and in particular in its 2003 opinion in In Re BLD, that it holds a strong policy favoring the preservation of error for appeal. And to the degree that the common law fundamental doctrine has ever been exercised, the Texas Supreme Court notes that it is a discredited doctrine. And the state would further note that in review of the fundamental law doctrine, This doctrine has been almost exclusively applied to criminal or quasi-criminal proceedings and has never, in the history, say, as far as the state was able to gather, ever been applied to eminent domain proceedings and any constitutional rights that may arise during such proceedings. Then in regard to the jury instructions regarding the jury charge, both parties submitted different charges to the jury, or to the court. The court and judge ultimately decided.
Were those filed or?
Yes, so they were offered. The state had filed its jury charge. I cannot today certify that LEDA had filed their version of the charge. To the degree they said, the state, I will acknowledge that there were two different charges that were offered. LEDA's charge, and I believe their briefing discusses it, had something like 10 different questions and 20 instructions, and was particularly lengthy. And the
so
state.
we did not find that in the.
Yeah,
in the
so
record.
I cannot recall today whether that was actually filed or was just presented. LEDA came to court with a variety of documents that had never been filed before in the case, and there were several that the judge chose to consider and not consider, but again, as none are referenced in the briefing at any point, it's difficult again for the state to go to the record and find exactly what complaint they are raising. However, to the degree that the court did draft its own jury charge, both parties agreed to the charge on the record. The judge went on the record, asked both parties in no uncertain terms, I have prepared the jury charge of the court and submit to you. He asked the plaintiff if we had any objections to the charge. I supplied that there was, that the state had no objections. LEDA was then asked if they had any objections to the charge. They simply replied, no, Your Honor. And for the purpose of even the citation, that's in the 4th volume on page 126 and 127, where you can find the fact that LEDA did not object to the jury charge that was offered, and so did not reserve that in terms of error. Even if they had reserved that charge, the measure of compensation in partial takings cases has always been the market value of the part taken plus damages to the remainder. You can find that in the Supreme Court case for Westgate Limited versus the state, which is a 1992 case, having no essentially negative opinions issued on it. And judges as a whole generally have wide discretion, obviously, to consider questions and instructions that may be appropriate for the jury. However, to the degree that the Texas Rules of Civil Procedure 277 asks for broad form questions generally to be submitted, which Westgate, the Supreme Court case, did again confirm. And the questions that were submitted to the jury reflect that. They were asked, one, what was the damages, or not the damage, as the value of the part taken that the state was acquiring, and then it was asked a second question, what do you believe the damages to the remainder to be? The state had submitted, as they had put those forward to the jury came back with a verdict. The first question was answered $34,000 and some change, and the second question was answered $0. So again, to the degree that such a submission was charged, it is adequate. It completely complies with both the Texas Rules of Civil Procedure 277 as well as the standards set out by the Supreme Court. And for all of these reasons, the state asks that this court affirm the trial court's judgment and hold that no abuse of discretion has occurred as to any of the issues raised by LEDA.
All right, thank you very much for your argument. The case of LEDA Development versus the state of Texas is submitted, and we are adjourned.
All right, thank you.
All right.